Samantha, lockdown creates great pressures for most people, especially for people dealing with the breakdown of a relationship. How do you manage those issues within these unprecedented circumstances?
Well, Chris, you're absolutely right. A separation is stressful and difficult when you're not in a pandemic, let alone people now being forced to live together due to quite draconian lockdown measures. But I'm pleased to say that we as practitioners and also the courts have adapted to this to ensure that we can continue to meet the needs of people that are going through a separation and need ongoing legal support and advice. As practitioners, we are still meeting our clients, but we are now doing this virtually. So we are meeting them via Zoom and conducting meetings this way. In many ways, that's often more convenient for clients because it means that they can get to a venue without having to travel very far, that they are relaxed because they're in their own home. But it also means they still have that face-to-face contact with their lawyer and also get to know their lawyer a bit and make sure that their lawyer is the right choice for them. In addition to this, courts have adapted and they are conducting telephone hearings, as well as, very similar to Zoom, some virtual meetings and hearings via the internet and via camera. So the courts are still facilitating those hearings. Prior to the lockdown restrictions becoming more restrictive, which has happened recently, they were also conducting some of those hearings face-to-face where they consider the case urgent enough to warrant it. But it's always worth remembering, Chris, that there are alternatives to going to court. And we as practitioners really do work very hard on behalf of our clients to try to find a resolution for them with as little conflict as possible. So in alternatives to meeting with a solicitor, you could go to mediation. Mediation is where an impartial third party who is trained to deal with the legal issues that flow from separation will meet with both parties to try to assist them in a dialogue to resolve the matters that they have between them. And this can be done again by Zoom with people in two different rooms and breakout rooms. And actually, for an awful lot of people, that is a better way to progress matters because they do feel very nervous about coming into direct contact face-to-face with their former partner. So in some ways, it can facilitate a better dialogue because people aren't in that sort of pressure cooker of all being together. In addition to that, we as lawyers can still have virtual meetings with our clients on the other side. And I've had a number of useful Zoom meetings with solicitors on the other side where we've worked through agreements, documents, or negotiations to really progress the matter on behalf of our clients. In addition, parties can hire a private judge in arbitration or a private FDR. And I know these are technical terms, but these are other alternatives that can be made available to the client so that we can progress matters without always having to go off to court. So the good thing is that we can still support the client to progress matters and meet their needs. But I would say this, we are sensitive to the fact that timing often to initiate proceedings is very important, or initiate action. And if you are living with somebody in a lockdown environment, you might not want to drop a divorce petition on their lap because it will cause fireworks to explode. And so we work with the clients to make sure that they're in an environment that they are comfortable with when we progress matters to ensure that their needs are met and that hopefully we can set the right tone in progressing matters to get as much cooperation as possible.
There is so much uncertainty at the moment, and I'm minded of people's employment. Many people have lost their jobs, others are on reduced incomes. So with that in mind, how do you go about agreeing a financial settlement and sticking to it if you've just been given your P45?
Well, it is very difficult, and we have had this arise a lot. Even if you were made redundant, whether it is in a pandemic or not, you are always obliged to maximise your earning capacity. So you would have to be showing a genuine effort to find and secure alternative work. So you should be showing the jobs that you're applying for, the type of packages you're applying for, the outcomes of those interviews, and if necessary, taking temporary work in between to maximise whatever income you can into your household. It is difficult. With child maintenance, the way that it works is that the Child Maintenance Service has the overall jurisdiction, i.e. the power at the moment to deal with child maintenance. So ultimately, if the two of you can't agree child maintenance, you would go to the child maintenance service and say, this is my current financial circumstances, assess me, and they will assess you on those and pay child maintenance in accordance with that. That also means that when you recover financially and you secure employment, that your child maintenance will go up because you'll be reassessed on the basis of your current financial circumstances. Spousal maintenance, which is maintenance specifically for the former spouse, is more difficult to agree if somebody isn't with a job and their future employment is looking a bit precarious. As I say, you are under an obligation to maximise your earning capacity. We would probably look at the history of your earning capacity and say, well, we believe that it's likely that once we have these difficult times, which do appear to be a blip, or at least we hope so, in the economy, that you will recover. And it might be that we attribute an earning capacity to you. Or in the alternative, I'd say to somebody, keep open those spousal maintenance claims, albeit at a reduced rate, so that when the fortunes of the other party are recovered, that you might be able to revisit that. And indeed, you might even put into the agreement that at present, a lower amount of spousal maintenance has been agreed, but it will be revisited if there is a material change in circumstances, and that it might be varied. It's also worth mentioning, Chris, that it's not just people negotiating a financial settlement, but people who already have a financial settlement and find that they're having to pay quite a high sum of child and spousal maintenance that they can no longer afford. Once a year has elapsed from that agreement being entered into, then any party paying child maintenance is allowed to go to the child maintenance service to be reassessed. So if their income has gone down, they can go to the child maintenance service and they will make an assessment based on their current set of circumstances. With regard to spousal maintenance, you should try to agree directly with your former spouse a reduction in that on a voluntary basis. You shouldn't just make a unilateral reduction, as that always causes problems. If they will not agree to a voluntary reduction, then I've already mentioned alternatives to court, such as mediation, arbitration, and so forth. But you would have to apply to the court if any of those avenues didn't work, to actually ask the court to formally reduce the amount of spousal maintenance that you are paying. Whilst you're going through that process, you should continue and endeavour to meet those maintenance payments, whether that be from a redundancy package, saving, and so forth. If you can't, then you can't, and arrears will accrue, and a judge will take a view as to whether or not you should pay those arrears. But you should continue to endeavour to pay that maintenance. And the court will take into account your circumstances as well as your former spouse's circumstances to decide if a reduction should be made.
And thinking about the restrictions that we're all living through, I can only imagine the complications that must exist with contact for one partner or another with their children, visiting, weekends, whatever used to be the arrangements in place. We're now dealing with a pandemic and the COVID-19 virus. How do you untangle that for a couple in this situation?
Well, again, it's always very difficult, and it's very emotive, children matters, whether there is a pandemic or not. You have two parents that aren't getting on, are often entrenched and polarised, and can't agree on anything. And they've probably got very different parenting styles. So you've got them being critical of each other. And then you've got into the mix the children, some of whom feel that they have control over the contact or feel that they are tied between both parents and have to humour them both. So it's a very difficult situation. What is clear is that during the pandemic, contact should continue to be facilitated. So it shouldn't just be put on hold because the pandemic's there and it can be used as an excuse to stop contact. The government being clear that children can move between two households to facilitate contact. And studies show that generally it is in the best interests of the children to spend time with both parents and having a meaningful and unfettered relationship with them both. Now, if you really can't reach an agreement with your former partner about how the children should be looked after, then I would say that you should consider mediation or family counselling. Now, with mediation, as I already mentioned, an impartial third party trained in family law issues will meet with you both with a view to helping you deal with and reach an agreement regarding the legal issues that flow from your separation. A mediation can also, if you find the right mediator, encompass the children, and they can meet with the children separately as well to understand how it is affecting them. And the good thing about mediation is that it gives you the opportunity to build up a rapport with your former partner and agree some common consensus and way forward. You have to remember you are going to be co-parenting with your former partner for the rest of those children's lives. So being able to agree some common ground and getting in place some boundaries is a good thing to establish as early on as is possible. It also takes away the potential of a judge making an arbitrary decision regarding your children, which actually neither you nor your former spouse believes are in their best interest, but are stuck with because you couldn't agree directly. Family counselling, I'm not suggesting it's the same as mediation, but again, that might help unpick why both parents are entrenched. It might help unpick why a child might have anxiety about going to contact or feels caught in the middle, and it gives those children a voice in that. So that's another way of saying, well, how can we sensitively address the needs of the children away from the court arena? Alternatives, again, to mediation are, again, hiring a private judge to make a decision, or if you really can't agree, making an application to the court. And sometimes that is appropriate, because if you've got someone who's very entrenched and inflexible, it can prevent the children from having, as I said, an unfettered relationship with the other parent. But I do say this, once it's in the court arena, you are relying on a judge to make important decisions regarding your children. And to a degree that it's a failure, because we as parents should be able to work together, and as practitioners work with parents to actually try to make the best decisions for our children. And as I say, build up a rapport with the other parent to co-parent as effectively as possible as separated parents. That has to be in the best interests of the child.